Thank you, Your Excellency. This CMC and application hearings are the matter of case numbers CFI 107, 2021 and CFI 108, 2021, and is being held by way of video conference before His Excellency Justice Nasser and Nasser. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimants are represented by Mohammed Sirkal, advocates and legal consultants. Lead counsel is Mr. Yash Bahiro. The defendants are represented by Davidson and Co. Lead counsel is Ms. Anson Sheung. Would the judge and the claimants and defendants counsel please confirm that the situation is as I have stated?
Yes,
That's
Your
correct.
Excellency.
Thank you.
So I think we shall start first with the security of cost application.
Thank you, Your Excellency. Then, if I may,
Then we'll go to the CMC. Yeah.
Thank you. If I may start now, then, Your Excellency, this is an application by the defendants for security for costs against the three claimants on the basis that there is overall reason to believe that in the event of the defendants succeeding and being awarded the cost of the action, they will have some real difficulty in enforcing that order against the claimants. Your Excellency, I'm sure you've read into the background of this claim, but for the purposes of submissions later, it's perhaps helpful for us to deal very briefly with the factual background in this matter. The claimants allege that there have been two loan agreements to the first defendant, Wellness United, of which the second and third defendants were the guarantors. No sums have been repaid, and the claimants claim damages or the unpaid debt from the guarantors accordingly. It is the defendant's case that whether under UAE law or English law, the loan agreements are null and void or unenforceable as a result. Under UAE law, the defendants rely on the Penal Code, Articles 400.
Just a minute, please. I think there is an issue with the connection.
Oh.
Now it's okay.
Okay.
So the Penal Code?
The Articles 458 and 459 of the Penal Code. And we say that therefore the loan agreements and the guarantees are unenforceable as a result. But in any event, as the claimants allege that say that the loan agreements and the guarantees are governed by English law, so there is a dispute about the governing law of the agreements, the defendants in any event say that the guarantees in English law are still unenforceable because they were not properly attested to under English law and the guarantees are invalid as a result. Having very briefly dealt with the factual background of the claim, I now would like to take you to the legal principles that are applicable to a security for cost application. Happily, the parties do appear to be largely agreed on the principles which are applicable to security for cost applications, although of course the parties disagree as to the extent to which they apply to the facts of this case. Now, if I can just perhaps briefly take you to part 25 of the rules of the DIFC court, and this is set out at paragraph 8 of my skeleton. That's going to be at tab H, page 604 of the bundle.
Okay.
Yes, and so it states there, the court may make an order for security for costs under Rule 25.100 if it is satisfied, having regard to all the circumstances of the case, that it is just to make an order, and one or more of the conditions in Rule 25.102 applies. So there is essentially in a security for costs application a two-stage test. So there is firstly a jurisdictional threshold, which means that the conditions set out in 25.102 must be met. This is followed by a discretionary stage by which the DIFC courts decide whether in all the circumstances of the case it is just to make such an order. It may be convenient now to just quickly look at the DIFC Court of Appeals decision in Al-Kharafi, which is at 624 of the bundle. And at paragraph 47.
Which page of the bundle?
624.
Okay.
So at this point, the Court of Appeal cites the English case de Brie and Fitzgerald to elucidate the underlying purpose of security for cost orders, which is that a defendant should be entitled to security if there is reason to believe, in the event of his succeeding and being awarded the cost of the action, he will have real difficulty in enforcing that order. In the second and third subparagraphs of paragraph 47, it then goes on to explain what difficulty in enforcing means. And it's not just the impecuniosity of a claimant, but also where, for example, an order for cost against a claimant is likely to be unenforceable or enforceable only by significant expenditure of time and money. And in that circumstance, the defendant should also be entitled to security. And if we look at paragraph 46, in the same case, it states that there can be no doubt that the words of RDC 25.101, if it is satisfied, having regard to all the circumstances of the case, that it is just to do so, give a wide discretion to the court applicable in relation to each of the RDC 25.102 conditions for granting security of cost. But of course, this discretion has to be exercised in accordance with established principles. So having briefly covered the general principles applicable to security for cost, I now propose to take you through the two-stage tests in relation to each of the claimants. So I will deal with the jurisdictional threshold applicable to the claimants first, and then the exercise of discretion as to each of the three claimants. And within each stage, I will take the three claimants in turn. If I can just deal with the jurisdictional threshold first, we've got three claimants. The first one that I propose to deal with is Mr. Bledjian, who is resident out of the UAE, and therefore 25.102 subparagraph 1 or condition 1, we say the claimant is resident out of the UAE. That there can be no doubt that that jurisdictional threshold is met for Mr. Bledjian because he currently resides in Greece.
Mhm.
As to Mr. Reuter and Mr. Pianese, there was previously some doubt as to whether these claimants were resident for the purposes of RDC 25 or mere holders of residency, but perhaps residing in reality residing elsewhere in the way that was cautioned against by the Deputy Chief Justice in Frontline Development Partners Limited. But just to be clear, as is set out in my skeleton, the current application against Mr. Reuter and Mr. Pianese only proceeds on Gateway 4, that is subparagraph 4 in Rule 25.102, as the claimants have not put down their addresses on the claim form. I don't propose to take you to the claim form directly, Your Excellency, but it is at page 292 of the bundle. And in there, you can see that the addresses haven't been shown and they've not been put down in the claim form as is required.
Which section?
F. So it's 292 of the bundle.
$292, yeah? Which tab?
292. 292.
No, which tab?
Tab 5. Section F.
It's
tab
also
5.
at section A, tab 2, page 7, Your Excellency.
Okay.
Yes. So in this case, the claimants haven't put down their addresses on the claim form. We say Gateway 4 or Condition 4 is met under the rules. So that quickly deals with the jurisdictional threshold. And now we turn to the exercise of discretion, which is the second stage of the test. Again, dealing with Mr. Bledjian first, he's not resident in the UAE, he's based in Greece. Now, the claimant overall appears to rely on the fact that of a property in Dubai, of which Mr. Bledjian claims beneficial ownership over, to say that there is no real risk of enforcement as a result. It's therefore convenient to consider actually what a real risk of enforcement is. If I can ask you to jump to page tab H in Al-Kharafi. And that is 624 of the bundle.
I think it's actually section I as opposed to H.
Oh yes, it's now section I.
I figured it.
624.
Okay.
Yeah. So at paragraph 49, if I can ask you to look at the last 3 lines of paragraph 49, essentially the difficulty of enforcement is a material consideration in considering whether or not to exercise the court's discretion to grant an application for security of costs. And if I can also then ask you to go to page 631, which is the case of Bestfoot Developments.
Okay. Okay.
Yeah. And so the takeaway at paragraph 6 from it, and if I can, I'll just read out to you. It is not, there was a real risk of that enforcement of any cost order made in the appellant's favor would prove impossible or impractical or difficult in the relevant foreign jurisdiction. And again, the takeaway from this is that the difficulty may arise not because of impossibility, but for example, where it's impractical because of cost delay or other practical factors militating against it. And it's convenient here that in this paragraph, that where Bestfoot Developments tell you what the appropriate test in a security for cost application is when we consider the risk of enforcement. That's a real risk as opposed to a speculative or a fanciful risk, and not one to be shown on it's not a likelihood on the balance of probabilities. All that must be shown is a lower threshold that there is a real risk that the defendant can't enforce its security in event of a cost order in its favor. And turning to the submissions and the application of this test with Mr. Bledjian, we do say that there is a real risk. It's not a mere possibility that the defendants will not be able to enforce against Mr. Bledjian. And there are 3 points in relation to this. First, the likely cost and delay in enforcing any order against Mr. Bledjian is particularly increased because there's no bilateral treaty or multilateral convention with Greece by which the defendants may easily enforce an order against Mr. Bledjian. But of course, the claimants come back and say, well, no, there's a property in Dubai. There is no real risk of enforcement. And we therefore turn to the second point, which is it's no answer to say that the mere existence of a property would mean that there is no real risk of enforcement. And that's actually been covered in Pisante and Logothetis. And that should be at page sorry, apologies, Your Honor, that's the bundle has just...
It's at 675
6-7.
of section I.
Thank you, Yash. Yes, sorry, my bundle's freezing slightly, but Judge, do you have the...
I do.
Thank you, Your Excellency. So if I can then ask you to turn to paragraph 51, which is at page 693.
Okay.
So here, the English Commercial Court deals with whether there is assets in the jurisdiction or within the relevant territory. But of course, the relevant claimant is outside the jurisdiction. And here there was a property worth some 11 million worth 11 million euros. And it was said that this was therefore good security for the defendants. Well, the judge in this case cast some real doubt as to whether the house could, in reality, be the subject of enforcement order, because it cited the judge in that case cited Holyoake and Candy, which essentially says that the real relevant question in relation to a cost order is whether the claimant can pay within the time ordered, and that's usually within 14 days or 28 days. So a company, for example, that has illiquid assets and could pay in the end, but is unable to pay with any high degree of promptness, is still within the rule. And if I can just read out to you the remainder of paragraph 51, whatever the value of Mr. Holyoake's interest in the property, it is inevitably going to take some time to realize. I cannot conclude on the material before me that Mr. Holyoake's ownership through the Irish companies of the property means that he will be able to meet an order for costs in favour of the defendants within anything like the normal timescale. And certainly in Pesante, later on, the judge did note that there were residents and possibly others, like Mr. Pesante's wife, who might have an interest in the property, to which no answer and no explanation had been provided. In which case, at paragraph 52, he therefore concludes that there must be some real doubt about whether the house could, in practice, be the subject of effective enforcement action, either at all or within a reasonable time. We say that that's a complete answer to the claimant's contention that a property alone means that there is no real risk of enforcement. A property is an illiquid asset. It's unlikely that they are going to be able to realize this asset within 14 or 28 days of the usual cost order. And therefore, it is within the rule and there is a real risk. But in any event, we also note that there has been no recent valuation provided for Mr. Bledjian's property, and the most recent valuation is when he purchased the property in 2017, some 6 years ago. So much then for the mere existence of a property in Dubai. But turning to the third point, it has been suggested that because Mr. Pianese and Mr. Reuter are resident in the UAE and would be able to satisfy a cost order, that means there are actually assets in the jurisdiction and no security should be ordered against Mr. Bledjian. Certainly, the defendants readily accept that any cost is going to be on a joint and several basis because the claims are nearly identical. However, the point is that there is no evidence to suggest either Mr. Pianese or Mr. Reuter are good mark for the cost, i.e. that they can pay the full costs owed. Certainly, Mr. Reuter has suggested that he owns 2 properties in the UAE, that he has interest in a number of UAE-based companies, but there's been no valuation provided for those properties. There's no identifying details as to what those properties are. It's also Mr. Reuter's evidence that he is married. So there's therefore a question as to what interest his wife may have, possibly, in those properties. It's unclear to us how those properties are held. For example, is it governed by DIFC law? Is it governed by onshore law? It's simply unclear. And the similar comments can be made with Mr. Pianese as well. We say that in both cases, imagination simply isn't enough. There's no evidential foundation to show that Mr. Reuter and Mr. Pianese are actually good marks for Mr. Bledjian. We turn to the final point on merits, which has been advanced by the claimants and relied upon by the claimants in their skeleton. And they say that the merits of this case are so strong against the defendants that this is a factor that ought to be taken in an application for security for costs. Your Excellency, if I can just turn you back to paragraph 8 of my skeleton, or actually, no, sorry, I'm just going to read that to you because that's perhaps better than jumping from bundle to bundle. But essentially, that investigation of the merits in the case is strongly discouraged because this is for obvious reasons. This is an interim application where the facts and the legal arguments have yet to be fully explored, and the court shouldn't undertake a mini trial, essentially, when there is limited disclosure and limited legal submissions so far on the substantive merits of the underlying claim. And Rule 25-110 makes it quite clear that merits of the claim should only be considered when the merits of the claim are so strong that they are almost certain to succeed. And we say that the claimant's case is nowhere near strong enough to consider the merits of the claim. If I can just take you to Section E, tab 3.
Okay.
This is the agreed list of issues. And you can see here alone, set out here, there's about 11 issues that the courts need to decide before the claimants are actually entitled to the relief that they seek. The parties disagree on the application of the UAE law. It's been suggested in principle that a UAE law expert may be helpful. But even as a matter of English law, there's an open question as to whether the guarantees are properly attested to under English law and whether they are therefore valid or enforceable. This requires both an investigation of fact and law. In Claim 107, this is going to require detailed evidence of fact, for example, as to whether the witnesses to the guarantee were physically present when the guarantee was attested to, or whether the signatures were simply signed at different points in time, different dates, different rooms. In Claim 108, it's apparent on the face of the document that there wasn't any proper attestation by the witnesses at all. And this will require an investigation into the legal effect of the lack of such attestation, because we see that only one party has had their signature attested to by a witness. There are no other witness signatures at all. The claimants appear to now say in their skeleton that the defendants are stopped from denying that the guarantees are valid. Well, estoppel is an equitable doctrine of which a court is entitled to exercise its discretion and requires detailed legal submission. And certainly there is authority to the effect that if a deed is on the face of the document invalid, estoppel simply doesn't apply. The claimants have also raised an alternative argument that the deed is still effective as a contract. But then there comes a question, because where is the consideration for the guarantees if they are contracts and not deeds? Past consideration, for example, entering into the loan agreement before the guarantee, is not good consideration. But really, these arguments do highlight the point that the claimants simply haven't met the threshold of getting to almost certain to succeed that would lead to Your Excellency involving the merits of the case in your exercise of discretion of the case. This isn't a case actually where it's so obvious on the facts that the claimants are going to succeed, and we therefore say that the merits of the claim simply aren't a factor that should be included in the exercise of your discretion. So those are the three submissions that are to be made with Mr. Bledjian. I therefore turn to Mr. Reuter and Mr. Pianese. I have already covered the points that whether Mr. Reuter and Mr. Pianese are really good marks for the claim, and certainly good marks for Mr. Bledjian. But as we have seen in the claim form, there's been no address listed in the claim form as is required under the rules. In fact, their witness statements are the first time that the defendants have seen the claimant's addresses at all. And it is particularly as both parties aver that they are on leases of apartments, we say that there is a risk that Mr. Reuter and Mr. Pianese's primary addresses may change, and there is uncertainty as to whether it would be most appropriate to attempt any enforcement proceedings, and therefore we would ask the courts to exercise their discretion. So to conclude on this security for costs application, we say that the jurisdictional threshold, the first stage, has been met with all three claimants. We say that in any event, the court is invited to exercise its discretion and grant the application. Mr. Bledjian being resident out of the UAE, there is a real risk of enforcement because the only asset that he relies upon is a property in Dubai for which there is no recent valuation at all. And being a property and a liquid asset, it is unlikely to be realized in time for any cost order to be met within 14 days, nor are Mr. Reuter and Mr. Pianese good marks. We say that certainly, if the court is minded to do so, security for costs ought to be ordered against Mr. Bledjian, certainly, even in and of himself, even if Mr. Reuter and Mr. Pianese are not included in that order for security for costs. As to Mr. Reuter and Mr. Pianese, Your Excellency, you have heard my submissions in relation to the effect of not having their addresses on the claim form. And of course, there is the question as to the sufficiency of their assets in relation to the question of good marks. So in all the circumstances, we do invite the court to exercise its discretion and grant this application. Your Excellency, those are my submissions.
Thank you. No questions so far. We'll move to the claimant, and then from there we'll see.
Thank you, Your Excellency. Good morning. My full submissions on the defendant's application is set out at section D of my skeleton. I will refer to that during the course of my submissions. I don't propose to turn up the skeleton itself, but I will give you the paragraph referencing. I've summarized the legal principles applying to security for costs at paragraphs 24 to 34 of my skeleton, but as Ms. Chung says, we are aligned on the basic applicable two-stage test, which requires the defendants to prove that a jurisdictional threshold is met before the court goes on to stage 2 to consider whether it should exercise its discretion in making the order. There are three claimants. Mr. Bledjian is to be treated differently to Mr. Reuter and Mr. Pianese, and that's largely down to their respective residency status. What I propose to do, Your Excellency, is deal with Mr. Bledjian's position first, because that appears to be the substantive focus of the defendant's submissions. So the starting point is it is accepted that the jurisdictional threshold against him is met, as he is resident outside of the UAE and he's currently resident in Greece. Thus, as regards him, the court is only concerned with the second limb of that two-stage test, which is whether it is just to make an order for security against him, taking into account all the circumstances of the case. And in my submission, Your Excellency, as you would have seen in my skeleton argument, we say it is not just to make such an order, taking into account all the circumstances. And I've set up my full submissions at paragraphs 39 to 41 of my skeleton. Developing those further, Your Excellency, I have three principal submissions as to why I submit the court should refuse to exercise its discretion. My first submission is that the defendants have failed to discharge the evidential burden on them to show that there is a real risk of not being able to enforce any potential order for costs, either in the UAE or in Greece, where Mr. Bledjian is currently resident. My second submission is that the underlying purpose justifying an order for security for costs has not been proven by the defendants, as there is no real risk of injustice to them in trying to enforce any potential future order for costs. And I say that's predominantly for two reasons. The first is that Mr. Bledjian has provided good evidence of assets he holds within the jurisdiction against which a potential cost could be easily enforced. And second, there are two co-claimants who are resident in the jurisdiction against whom a cost order could be enforced because it would be joint and several liability, as Ms. Chung accepts. My third submission as to why the court should not exercise its discretion is that this is a rare case where the merits of the claim ought to be taken into account, because it is highly likely that Mr. Bledjian and the other claimants will succeed at trial, and therefore this militates strongly against the making of an order. I've heard Ms. Chung's submission specifically in respect of the merits. Your Excellency is well versed in both English and UAE law, And I'll take you through why her submissions are just not sustainable as a matter of law, but also as a matter of fact. So if I may move on to my first submission, Ms. Chung and I both rely on the Court of Appeal decision in Al-Kharafi and Bank Saracen. That was a case in which I actually acted for the bank on the appeals. That is the leading authority in this jurisdiction for security for costs. But Your Excellency, it's worth going through that decision in a bit more detail because there's more to it than we say the defendants present. So if I can ask Your Excellency to go to tab I of the bundle, it will be section 2, and we're going to start at page 624. Ms. Chung has already taken you to parts of the judgment. But the starting point is paragraph 46, where the Court of Appeal set out the two-stage test and say that the court's discretion, however, is to be exercised in accordance with the established principle. If we then look at paragraph 49, you can see that the court here is quoting from the rules of the DIFC Court 25.109, and they say that the underlying purpose for these types of orders are reflected in that particular rule. And what that rule says is that the defendants have to provide an affidavit or witness statement in support of an application for security of costs, which should deal not only with the residence of the claimant and the location of his assets, but also with the practical difficulties, if any, of enforcing an order for costs against him. So there are three things the evidence that a claimant making an application has to cover in evidence: the place of residence of the respective claimant, where the assets are located on their evidence, but also evidence dealing with the practical difficulties of enforcing against them. It's not enough simply to turn up and say, we're going to have difficulties because they're based in another jurisdiction. You have to provide evidence of what those practical difficulties are. And in the Al-Kharafi case, the allegation being made by the applicant defendant concerned the practical difficulties with enforcing an order for security in Kuwait. And both parties in that case adduced expert legal opinion from Kuwaiti lawyers. And if I can just make that point good, Your Excellency, if you look at page 622 in the same section, you will see at paragraph 37, you third line down, Mr. Bassett, who was one of the counsel, draws attention to the evidence before the judge of Mr. Alex Salah, a lawyer practicing in Kuwait. And then at paragraph 39, you will see that the respondent also produced evidence from a legal expert who was a Kuwaiti lawyer, and his name was Mr. Bassam al-Mutakaffa at paragraph 39. So, Your Excellency, you can see by way of the Al-Kharafi case that actually the evidence has to be provided as to what they say are the practical difficulties of enforcement. And in this case, if we take it through to its end at paragraph 51, what the court ultimately found on the evidence before it is that they were unable to reach a conclusion as to the magnitude of the risk of inability of enforcing an order in Kuwait of a DIFC court order. So the court, notwithstanding the fact they had competing expert evidence, were not able to reach a conclusion on the magnitude of the risk of not enforcing a DIFC court order in Kuwait. And therefore, the Court of Appeal refused to grant security on that basis. What the court also says at the end, you can see in the last sentence, is they say, as part of that evidence, further, there is no evidence as to what the enforcement procedure would have to be employed, how long the process would take, or how much it would cost. So from Al-Kharafi, Your Excellency, we see what exactly is required. So bearing in mind the burden is on the defendants to establish the facts sufficient to justify an order for security, I want to take the court to the evidence relied upon by them in making this application, because in my submission, it demonstrates that they have not discharged the burden. Not only have they failed to identify where Mr. Blejian's assets are located, they have provided absolutely no evidence whatsoever as to what practical difficulties they say they will face. So if I may ask Your Excellency to turn to the third statement of Ms. Turovskaya, it's at section F, it's document 3, and I'm looking at page. It starts at 269, but I'm going to start at page 270. Your Excellency, there are 2 witness statements that have been provided by the third defendant. They are virtually identical, but one's for each claim. So I'm just going to focus on this one, but my submissions equally apply to the other statement. So if we look at paragraph 5 of 270, she starts off by saying the defendant's position is the claims are all void and without merit. They say the defendant's apprehension is not unfounded. The defendants are not aware of the addresses for the claimants, and by their own admission in the particulars of claimant number 2 is no longer based in the UAE and is based in Greece. I think that's actually wrong. She means claimant number 3. Therefore, the defendants have a genuine and clear reason to believe that the claimants have no assets in the UAE, which the defendant can turn to in the event the claimants fail to honour any judgment as to costs which may be entered against them. So this unfounded apprehension as to whether the claimants have assets to the UAE is actually not relevant to considering whether the threshold condition has been met. That's very much a binary question. Are you resident in the jurisdiction? Yes or no? We then go on to paragraph 8. Again, she sets out the defendant's concerns. And when I say the defendant, this statement is only on her behalf and the first defendant. The second defendant has not made any application or provided any evidence. She says, again, the defendants are concerned that they are unaware of the claimant's assets in the UAE. And again, claimant number 3 is based in Greece and is not a resident in the UAE. She then goes on to set out schedule of costs. And then we look at paragraph 11. She sets out the rules of 25.101 and 102. And Your Excellency, this becomes particularly important as we look at the other 2 claimants. You can see highlighted under 25.102 is only subsection 1. Subsection 4, which Ms. Chung relies on now as against the other 2 claimants, is not highlighted, and there is nothing said in this statement about pursuing the application under that jurisdictional threshold. And then we can see at paragraph 12, as set out above, the defendants have no information whatsoever about the whereabouts of the claimant's business operations and or its assets, and that the claimant number 2 resides in Greece. Accordingly, there are strong and valid concerns in the event of a favourable cost order, the defendants will face severe impediment in its execution. So they have identified, with respect to Mr. Blejidian, although they've identified him incorrectly as claimant number 2, they have identified he's resident in Greece, and yet they've provided absolutely no evidence as to what practical difficulties they would say they would face in enforcing. But they've also failed to identify where his assets are, and he is the one who has put in evidence to say, I have a property that's unencumbered, that's solely owned by me in the jurisdiction. So by reference to the clear criteria set out by the Court of Appeal in Al-Kharafi and Bank Saracen, the evidence adduced by the defendant has only identified the place of residence in Greece. It fails entirely to deal with the other requirements that the Court of Appeal says is necessary to reach a conclusion. And in fact, Your Excellency, the defendants have made absolutely no attempt, none whatsoever, to inquire about Mr. Blejian's assets or the location of his assets prior to issuing the applications. Now, Your Excellency will be incredibly familiar with the process and how this normally works. And what you would normally expect is to see correspondence between the parties' legal representatives before an application is issued. And one of the reasons you have letters going to the lawyers before is exactly to prevent premature applications being made without all the facts being established. In this case, they issued the application. They didn't send a letter to any of the claimants or their representatives who have been on record for over a year and a half. They made no inquiries about where the assets were, whether they were willing to voluntarily provide security, nothing. They issued the application and failed to provide any of the evidence that the Court of Appeal says is required. And what we have now is some vague and unspecified reference in the witness statement to anticipated difficulties in ascertaining and allocating assets. That's not even the test. The test is what are the practical difficulties of enforcement. And Ms. Chung attempts to get around this by making some vague and unsupported submissions about difficulties in Greece because of a lack of a bilateral treaty or multilateral treaty in Greece. But the rules under 25.109 is absolutely clear. The the decision in Al-Kharafi is absolutely clear. What there must be is not vague and unsupported submissions. There must be clear evidence to support what are the practical difficulties in enforcing an order for cost if they were to succeed at trial, including what the enforcement procedure would be. They've provided nothing about that. How long the process would take, there's nothing about that, and how much it would all cost. Again, absolutely nothing about it. So in the Al-Kharafi case, all of that was dealt with by way of expert evidence. However, the court still found that was not enough to enable it to reach the conclusion as to the magnitude of the risk of inability to enforce the order abroad. And that's what they needed to do here. Ms. Chung's reference to enforcement in Greece in her skeleton argument, but also in her oral submission, in any event in my submission, is misconceived, because Mr. Blagirian has provided evidence of a substantial asset in the UAE, i.e. within the jurisdiction. And therefore, it's not enough simply to say we're going to have difficulties enforcing in Greece. The evidence that's before the court and that has been provided to them is that there are assets within the jurisdiction. So actually what Ms. Chung and the defendants need to show is why there would be practical difficulties in enforcing a cost order in the onshore courts in the UAE, not in Greece, because they've provided no evidence of what assets are abroad and where those assets are based and what the difficulties are. So the burden on them is to prove the difficulties that would exist in enforcing in the UAE. And Your Excellency is going to be more familiar with that than anyone else. There are none. So in my submission, for the obvious reasons, no such practical difficulties exist, and the burden, the evidential burden on the defendants has not been discharged. So to conclude my first submission, Your Excellency, I submit the defendants have failed to discharge that burden of showing, in respect of Mr. Blagirian, where his assets are located and what practical difficulties exist for enforcing an order. And that, in my submission, is enough to dismiss the application as against him altogether. But tied to that, if I may move on to my second submission, and that is that on the evidence that has been put before the court, leaving aside all the issues I've just identified, it's clear that there is no risk of injustice to the defendants in enforcing a potential future order for costs because of the asset he has in his jurisdiction. If I can just take Your Excellency to the evidence that's on that asset, I don't think Ms. Chung took you to it during her submission. It's in his witness statement at paragraph 16, so that's section F of the bundle, document 8, page 347.
Okay.
We can see at paragraph 16, Your Excellency, what he says is that whilst I'm no longer resident in the UAE, I am the ultimate beneficial owner of a property in Dubai, which I've owned since 2017. Property is an apartment which is held by Reuter Investment Limited, of which I am the sole owner. The property was purchased for 2.95 million dirhams, approximately $800,000. The value in the property in Dubai far exceeds any likely cost all the defendants would obtain against me in the proceedings. The principal value of my claim as set out above is just under $300,000. Defendant's purported cost estimate is $1.1 million for a simple debt claim. So what he's saying here, and I can take you to the underlying documents to show, is that he's the ultimate owner of an unencumbered property in Dubai, which he's purchased for just over $800,000 in 2017, which is held for a company. So if we look at page 361, we can see this is the title deed to the property.
Just a minute, please.
Apologies, Your Excellency, my bundle's also frozen.
Okay.
I don't see, my bundle doesn't seem to be working, Your Excellency, but I do know the document off the top of my head. What you will see there is the title deed, and you will see at the top there's a reference to the fact that the property is not mortgaged. You'll see further below in the squared table that Juncker Investment Limited is the owner of the properties. And you'll see just below that in the smaller print that it was purchased in August 2017 for 2.9 million dirhams. It's just loaded. No, it's frozen again. Sorry, Your Excellency. But if I can ask you to go on to the next page, if your bundle is working. Here we go. We can see this is the certificate of incumbency. And what this confirms, if you look just at the bottom, shareholder, Andre Philip Blagian, you can see he holds 1,000 shares, so he's the sole shareholder of this company. So the evidence that's before this court shows that he has the ultimate sole ownership in this property that was valued at $800,000 in 2017, which is when it was purchased. Now, Ms. Chung makes two criticisms as to why this property is not sufficient to satisfy the court that there is no risk of enforcement. First, she says at paragraph 25A of her skeleton that the relevant question for the purposes of enforcement is whether there are sufficient assets that could satisfy a cost order within 14 to 28 days. She relies on an English authority of Holyoake and Candy, albeit she's not produced that authority for the court. Now, Your Excellency, that submission is just wrong as a matter of law, but regrettably, it's also misleading in the way that it's put. Now, what Ms. Chung does in her skeleton argument at paragraph 14 is she refers to the dicta in the authority of Holyoake as referred to in another case, which is Pesante. And she says this is authority for her proposition, which is there needs to be sufficient assets to allow a cost order to be settled within 14 to 28 days. That's wrong. That's only specific to companies where a company is the subject of a security for cost application. But if we can go through the authority of Pesante, it's at section I, it will be document 2 and page 675. So this is a reported judgment, Your Excellency. So if we start off with the head note itself on that page, you can see this is a summary of what the judgment is. In proceedings involving 4 claimants, the first being an individual not resident within the jurisdiction, and the remaining 3 non-resident corporate bodies, it was appropriate to order security for costs under Part 25 against only the latter, since the former was resident in Greece, a contracting state. So the individual was resident in an EU member state at the time when the United Kingdom was part of the EU, and the 3 resident companies were non-resident companies in the UK. I think one was based in the BVI and the other in the Marshall Islands. So this decision was all about security being ordered and made against 3 non-resident companies, not an individual. And it goes on, it followed the court had no power to make security for costs against him. However, so far as the corporate bodies were concerned, it was common ground that none were listed in CPR 2513 2A2. And accordingly, the court had prima facie power to order security. So that's what the judgment is actually all about. And if we go on to paragraph 19 of the judgment, which is at page 680, this is particularly important. We can see this is the condition set out in CPR, the English Civil Procedure Rules, 2513(2). And Your Excellency, if you see subparagraph C, which is right at the bottom of the page, it says the claimant is a company or other body, whether incorporated inside or outside Great Britain, and there is reason to believe that it will be unable to pay the defendant's costs if ordered to do so. Now that mirrors the wording exactly of the RDC Rule 25.102 subsection 2. And that is the only condition, as Your Excellency will know, that requires a belief to be shown that a claimant company will be unable to pay its costs when ordered to do so. None of the other subsections under 25.102 has the same caveat as subsection 2. And if we go on into the judgment at paragraphs 45, that's at page 691.
Okay.
You can see at paragraphs 45, these are the assets that were in question. And you can see number 2 is the main residence in Athens, i.e. a property that was valued at more than $11. So that was what the subject was. It's whether Mr. Pasante's property, given he was a co-claimant, was sufficient to make him effectively a good mark to cover the company. So you then go on to paragraphs 48 to 50, and now this is the part of the judgment at page 692 that deals with the property. So Your Excellency will see at 48, he states he has a real estate assets located in Greece worth 15 million. The only such asset to which details have been provided is a substantial house in Athens, which he describes as his main residence. Now, the judge goes on to say at 49, I would agree with the claimants that it seems very unlikely that this house would, by the time any adverse cost award came to be enforced, have declined in value so far as to not cover the defendant's estimated costs. However, I do not consider the possibility of enforcing a judgment against the house as a satisfactory basis on which to conclude that the prima facie obstacles to enforcement arising from the second to fourth defendant's place of residence do not arise or cease to be relevant. And then what the judge does at paragraph 50 is he goes on to set out the reasons as to why he's not satisfied that the property can provide good security. And he says the 2011 market appraisal refers to the property as being owned by Mr. Pasante and his wife and the third party. Mr. Pasante explains in his second witness statement that the third party was his late mother, who passed away in 2019. The valuation was obtained upon her death to facilitate his purchase, and the property has since then been in his sole name. Mr. Pasante does not provide any explanation as to how his wife ceased to have an interest in the property, nor does he provide any documentary evidence. So there is actually question marks over what the ownership structure is of the property. We don't have that here, Your Excellency, because I've taken you to the documents that show that this is entirely Mr. Blegian's asset. We then go on to paragraph 51, and this is what Ms. Chung relies upon to say that the question is whether a cost order can be paid in 14 to 28 days. He goes on to say, in these circumstances, there must be real doubt about whether, and if so, in what timescales the House could in reality be the subject to an enforcement action. And then he quotes Holyoake and Candy. And if you look at the quote, you'll see there is another aspect to it. It is well established in considering for the purposes of 2513(2)(c), which Your Excellency will remember we looked at specifically deals with companies and not individuals, whether there is reason to believe that a company claimant will be unable to pay the defendant's costs if ordered to do so. The relevant question is whether it would pay within the time ordered. That is usually 14 to 28 days. So what that quote actually says, or what the judge is doing there in relying on Holyoake and Candy, and you'll see he goes on at paragraph 52 to say there are concerns in this case around the ownership, the fact that family members occupy the residency, what Mr. Pasante's interest is, and the fact there was no documentary in support of his statement of sole ownership. Those are all the reasons given by the judge as to why the property could, in practice, not be subject to effective enforcement action within a reasonable time frame for a claimant company. None of that applies here because Mr. Blegian has provided documentary evidence of his sole ownership, but also under subsection 1 of 25.102, there is no caveat as there exists in subsection 2 that says it must be able to pay an order within when it's ordered to pay so. So the 14 to 28 day period that Ms. Chung says is relevant is actually not relevant, and it's wrong to say that it is as a matter of English law. That's only relevant when you're looking at whether security should be ordered as against a claimant company, not an individual. And the reason you look at the 14 to 28 day order is because the wording of subsection 2 is very specific to say there is reason to believe the company will be unable to pay the cost when it is ordered to do so. That wording and that caveat does not exist in any of the other subsections. So it's simply wrong to say that that is the question the court has to look at. So there is no general test or question as to whether there are assets that can be realized and have to be realized within 14 to 28 days as against an individual. There is no separate requirement for promptness of payment, as Ms. Chung wrongly contends, because under RDC 25.1021, which is the gateway in which she relies on, there is no such caveat. The only question is whether the claimant is resident outside of the UAE, which we accept he is. So once you get past that, what the court, as confirmed in the Al-Kharafi case, has to do is look at what is the evidence of the practical difficulties of enforcement. And again, I reiterate my point, there is absolutely no evidence as to what the practical difficulties would be. So in my submission, Ms. Chung's first point, her criticism, is a bad one, and it's not one that's actually correct as a matter of English law. The second criticism she makes about the fact evidence has been provided about this property is she says there is no recent valuation provided for this, with the most recent valuation being 6 years ago. And she sets that out at paragraph 25b of her skeleton. In my submission, that's an equally bad point. There has been no evidence adduced by the defendants to suggest that the valuation of 800,000 from 6 years ago has materially changed. The evidence before the court is that the property was valued at 800,000 in 2017 when it was purchased. Insofar as the defendants want to challenge that, or they want to submit to the court that that evidence should not be accepted, they should have put in evidence to that effect, but they have not done so. The burden is on them. They had the information about the property because we provided this back at the end of March when the statements were filed. They had information about the property, they had information about its location, they had information about its building. Therefore, it was easy for them to obtain information about its likely value, even on a superficial basis. It was open to them to file evidence in reply, challenging the valuation of this property, but they haven't done so. So the only evidence that exists before the court is that this property is a substantial property that was valued at 800,000. Moreover, to put it into perspective, Your Excellency, it's worth remembering that the combined principal value of Mr. Blejian's claim in both claims 107 and 108 is approximately $400,000. That's the value of his principal claim that he says needs to be returned under these loan agreements. So if the court was to adopt a broad brush approach to costs, which is normally what happens, it's generally the case, well, I accept not always, but generally the case that costs are likely to be somewhere in the region of 10 to 20% of the value of the claim, depending on the complexity of the issues. Now, in my submission, it is absolutely obvious that this is not a complicated case. It's a simple debt claim that in my submission turns on some limited legal issues. And as such, the cost should not be high. Assuming the 10 to 20% broad brush figure that I've suggested is appropriate, that would estimate the potential cost liability for Mr. Blejian to be somewhere between $40,000 and $80,000. But the value of the claim, the principal value of the claim as a whole against all of the claimants is just shy of $950,000. So again, taking that broad brush approach, you're only looking at somewhere between $80,000 to $150,000 in terms of what the cost should be and what would be reasonable and proportionate. So it's just not credible for the defendants to suggest that the property, the value of this property, would have fallen somewhere between 90 to 95% since 2017, even if the market in Dubai has softened since then, of which they've produced no evidence. So the court, in my submission, can only proceed on the basis of the evidence that's before it. And the only evidence before it is that there is a substantial unencumbered property in the UAE, which is solely ultimately owned by Mr. Blejian, where no evidence has been adduced as to any practical difficulties in enforcing in Dubai against that property, should they need to. So for that reason, the defendants have failed to prove that the underlying purpose justifying an order for security has been made out, because there is simply no risk of injustice to them in trying to enforce an order for costs if they ultimately succeed in the UAE. So if I may move on to my third submission, Your Excellency, we do say the court should take into account the merits of the claim, because in my submission, the claimants are highly likely to succeed at trial, and the defendants have no real prospects of succeeding in their defense. Now, Ms. Chung and I are agreed on the principle, which is that the courts should take account of the merits only where the claim is almost certain to succeed or the defense is almost certain to fail. And I've set out my submissions in full at paragraphs 40 of my skeleton. I don't intend to repeat that in the same detail as part of my oral submissions, but I just want to deal with some of the points that were raised by Ms. Chung. Now, she says this is not a simple trial. And one of the reasons she says that is because she took you to the list of issues, Your Excellency, and says, look, there are 11 issues that are agreed by the party. This is all very complicated. It's all going to require detailed investigation. That's a complete red herring. The reason there are 11 issues is because of the improper way in which the defense has been pleaded. If I can just take you to it briefly, Your Excellency, it's at section A, document 4, page 83. And again, this is the 107 defense that's virtually identical to 108. But if you look at paragraph 2, this is the starting point. What the defendants say here is they deny the claimant's claims in toto, i.e. in the totality, and no part of the claimant's claim shall be deemed to have been admitted by the defendants for lack of specific denial. So it's a blanket denial to everything. There's a blanket denial to the agreements being entered into, them being signed, whether the money was received, whether the money was paid. That's what the effect of that defense is. It calls into question everything. It's actually not compliant with RDC Rule Part 17 because you're not supposed to have blanket denials. You have to give a reason for it. And the rest of the defense just goes on to set out points about Article 458, 459 of the UAE Penal Code in 2021, which doesn't even apply in this case. It would be the 1987 Penal Code, given the time at which the agreements were entered into. It then goes on to talk about the Civil Transactions Law on the basis of it being an illicit gain because of the Penal Code. It sets out a completely unspecified claim against the second claimant about conflict of interest, which by definition can't have any impact onto the validity of the contract. And then it concludes. So there is absolutely nothing other than a blanket denial. But what the defendants do not specifically deny, and they still don't deny it now because they can't, is that they entered into both loan agreements. They signed both agreements. They signed and entered into the 107 guarantee and the 108 guarantee. They also do not deny that the first defendant received the monies, and they don't deny that they haven't repaid any of the monies. So where they don't specifically deny any of that, it's very hard to see how they can deny there isn't a claim in debt. So what they do instead is come up with, well, it's unenforceable and invalid as a matter of law. And we say that's just wrong. But the list of 11 issues is reflective of what is a poorly drafted defense. It's not reflective of the issues in the case. And Your Excellency, what I want to do is actually show where the issues are narrow. And this is included in Ms. Chung's skeleton at paragraph 7. So if we look at section I, document 1, paragraph 7, in her summary of the claim, she correctly states at paragraph 6, we say there are 2 agreements, there are of which the second and third defendants were guarantors. No sums have been repaid under those agreements. That's the simple debt claim. And then she says, in summary of what the defendants' allegations are, they allege the loan agreements and the guarantees are null and void and are unenforceable, whether in UAE law or English law, because of Articles 458 and 459 of the UAE Penal Code, and B, in any event, the defendants aver that the guarantees are not properly attested under English law and they're invalid and enforceable. So there are 2 questions of law. There are not 11 issues, because the simple reality is if the court was to resolve these 2 questions of law, the rest of the issues fall away, because clearly there is the agreement, clearly it's been breached, clearly there's been loss, and we say clearly we're entitled to interest. So there are 2 legal issues. There are no complicated issues of fact, because there is no denial that they entered into these agreements, received the money, and have failed to repay it. So on those 2 questions of law, we say we are certain to succeed on them. Now, as to the first one about Articles 458 and 459, even if the defendants could show that that applies, which in my submission they can't, the test is whether it is illegal as a matter of English law. So, Your Excellency, if I can just go back to the amended defense at Section 8, Document 4, page 84, we can see there, they have quoted Articles 458 and 459. And again, I don't accept this actually applies, because the correct penal code would be the 1987 version. The 2021 version obviously came into force after the agreements had been entered into. But you can see, and Your Excellency is very well placed, both being well versed in English law and UAE law, to see that Article 458 and 459 is talking about persons lending to another physical person. So it's about individuals lending to each other. So in my submission, they can't show that 458 or 459 applies, because the transaction in this case doesn't concern lending between physical persons. Rather, it concerns lending from individuals to a company. The recipient of all of this money was the first defendant company, Wellness. They are the ones who received this money for working capital purposes. That much is stated clearly in the loan agreements. And the loan agreements themselves are governed by English law. Now, Ms. Chung, in her submission, said there's a dispute about the governing law of the agreement. I'm not entirely sure why she says that, because there's no pleaded basis for that. But in any event, it's inescapable that all four agreements have English governing law clauses to them. So those agreements are governed by English law, and the Court of Appeal in the DIFC, in the Emirates MBD and Advanced Facilities case, confirmed what the relevant test is when an illegality defense is run to try and invalidate an English law governed contract. So if I can briefly take Your Excellency to that, it's at Section H, tab 2, page 551.
It's loading, so let's.
Forgive me, Your Excellency, I didn't hear that.
It's loading, yeah?
Okay, yes.
Yeah.
I'm just going to get up the relevant. I'll be starting at page 573, Your Excellency.
$500.
573. And where I'm going to be starting at is paragraphs 128. Does Your Excellency have that?
Please. Okay.
So this is the Court of Appeal's decision in Emirates MDB and Advanced Facilities. And starting at paragraphs 128, they deal with one of the arguments being run, which is illegality in public policy. And they say, though unnecessary to do so in light of our conclusions thus far, in deference to the arguments advanced, we very briefly express our views in public policy and illegality. 129, at the outset, we underline that the MMA, which is the contract in that case, is governed by English law, not by UAE law or Sharia law. In consequences, the hurdle faced by the defendants, even at an immediate judgment stage, is insuperable. The relevant test was set up by Mr. Justice Phillips, as he then was, in Lamenda Trading and African Middle East Petroleum at 461. And then it goes on to set out what the test is when you run this type of illegality defense. He says the English court should not enforce an English law contract which falls to be performed abroad, where it relates to an adventure which is contrary to the head of English public policy, which is founded on general principles of morality, and two, the same public policy applies to the country of performance, so that the agreement would not be enforceable under the law of that country. In such a situation, international comity combines with English domestic public policy to militate against enforcement. And then 130, very specific to that case, with respect, a financing facility which does not comply with the AAOIFI standards, important those standards are, is not contrary to any head of English public policy, even assuming that it is contrary to the public policy of the UAE. So what the court is confirming and summarizing there, and it's well accepted under these Raleigh brother type arguments, is that where a contract is governed by English law, which is the case here, it is not enough that the charging of interest would be illegal or contrary to the public policy of the UAE, which it is not. It would also have to be contrary to any head of English public policy. Interest-bearing loans, even as between physical persons, is not contrary to English public policy. It's not contrary to any policy in England, but in any event, 458 and 459 of the Penal Code have no application because we're not dealing with physical to physical person lending. So in my submission, the claimants are almost certain or highly likely to succeed in showing that the loan agreements are valid and enforceable as a matter of English law and UAE law. And where that is the case, as we've seen from Ms. Chung's skeleton, there can be no serious dispute that the first defendant is in breach of those loan agreements and therefore owns a debt, because they don't dispute the fact they entered into these agreements, received the money, and failed to pay it back. That's not that. Those factual disputes do not form part of their case. And that's why it's not summarized in Ms. Chung's skeleton argument at paragraph 7. And as to the second issue, the legal issue that she raises, she says in any event, the guarantees are invalid and unenforceable because they were not validly executed as deeds. Now, that is a brand new defense that was introduced into the error amendment, which wasn't responsive to the actual amended particulars of claims that were put in. And I'll deal with that in the context of the CMC, Your Excellency, but it's a new argument that was raised. And we say that's complete nonsense, because even if the defendants are correct that the guarantees are not validly executed as deeds, they accept that English law governs those agreements, which is in their pleading. And as a matter of English law, the guarantees are still enforceable as normal contracts. And what we heard today is an incorrect submission on the application of estoppel, for which there is no authority before the court. But what Ms. Chung says is that even if it's enforceable as the contract, where is the consideration? And again, that's a misconceived submission, because the law in England is very clear that consideration still remains good consideration for the terms of the guarantee. And if I can take you to the authority of Signature Living and Sulyok, it deals with this. It's at H2 document 2, page 576. That starts, and I'm going to rely on paragraphs 29 and 34. Paragraphs 29 starts at page 582, Your Excellency.
Yeah.
So you can see this is the judge's decision. I have no hesitation in preferring the submissions of that particular counsel, Mr. Overhand. I am entirely satisfied that the law is, and still is, as stated in the penultimate paragraph 2021 of Andrews and Millett on the law of guarantees. There, it is said that if an otherwise complete contract of guarantee is intended to be embodied in a deed, but the formalities have not been complied with, the creditors can still enforce the agreement. That proposition is said to be exemplified by the decision of Mr. Simon Brown QC, sitting as Deputy Judge of the QB Division in the case of Lloyd's TSB and the Dyer House. There, W, the alter ego of a group of 5 companies, had signed an omnibus guarantee in respect of a facility afforded by the bank to those companies at his request. The guarantee required another signature in order to make it effective as a deed. Mr. Simon Brown QC granted summary judgment against W on the basis that, although the guarantee was not a deed, W had sought a facility for his companies which the bank had provided in consideration of his promise to guarantee repayment. Consequently, a contract had arisen which the bank was entitled to enforce. And if we look at 34 and 35, this deals with Ms. Chung's point on consideration. That's at page 584. You can see paragraph 34, again, the judge confirms, in my judgment, the law is accurately stated in the penultimate paragraph of paragraph 2021 of Andrews and Millett, the law of guarantees. If an otherwise complete contract of guarantee is intended to be embodied in a deed, but the formalities have not been complied with, the creditor can still enforce the agreement. He goes on to say, I am also satisfied in the present case, the guarantee agreements were sufficiently supported by consideration, again, for the reasons given by Mr. Owehand. In the case of Mr. Solyuk, the loan would appear to have been made at the same time as both documents were entered into. In the case of Ms. Cocorella, the loan appears to have been advanced the previous day to the entry to the relevant agreements. However, I am satisfied that the loan was entered into as part and parcel of a series of interlinked transactions involving not only the entry by the borrower into the loan agreement, but also the entry by the applicant company into the guarantee. So that shows consideration is going to be good consideration here, because A, the guarantees were entered into at the same time as each loan agreement were entered into, therefore on the same day. But secondly, those transactions are interlinked because the loan agreements make specific reference to a guarantee, a personal guarantee, needing to be provided by the second and third defendant. And if I can just take you to that document, Your Excellency, it's at section A, document 3. I'll just take you to the one relating to claim 107. It's the same concept for claim 108. So if we see page, it starts at page 31 of section A. Does Your Excellency have that document?
Yes.
So we can see at 31, it's effective date 15th of February. You have the parties, which is the company, the original shareholders, which is the second defendant, and the investors, which is the free claimants. You've got the loan amount at the bottom. And if we go down to page 33, you can see the security for the loan. Any amount due to the investors under the convertible loan until full settlement or conversion is applicable shall be secured as follows: a personal guarantee by Jacob Logothesis and Angela Turovskaya, and a post-dated check. So we can see the loan agreement specifically provides for a personal guarantee. And if you go on to page 36, that's where you have the deed of guarantee, which is dated the same date, which is provided by the second and third defendant. So it's absolutely obvious in my submission under English law that even if the formalities of a deed are not met, the guarantee is enforceable as a contract. And this argument about there not being sufficient consideration is a bad argument that can't be made good as a matter of law. There's no amount of factual evidence that's going to be able to overturn what the law says, which is that they are still enforceable as a contract and they are good consideration if they're entered into at the same time and they are linked to the transaction, which this one is. So, Your Excellency, as against Mr. Blegian, which is what I'm still dealing with, notwithstanding that the jurisdictional condition has been met, for the reasons I've explained, it would not be just to make an order for security against him, taking into account all the circumstances in the case. The reality is he has a claim which is almost certain to succeed, which is limited in its issues. But even if you ignore the merits, the defendants, as I've said, have failed to discharge the burden on them to show there would be any practical difficulties in enforcing an order for costs in the UAE, which is where his asset is, or even in Greece. So what I'll do now, and I can deal with this one a lot more quickly, is move on to Mr. Reuter and Mr. Pianise. Now, regrettably, the defendants have changed the basis on which their application against those two claimants have been made, because they now realize both are residents in the jurisdiction, and they say the jurisdictional threshold has been met because they haven't provided their address on the claim form. So, Your Excellency, I took you to the evidence of Ms. Tereskova, and I highlighted the point of paragraph 11, which is the only subsection that was highlighted and that they spoke about against all claimants was subsection 1, i.e. that they were not residents in the jurisdiction. This new position of subsection 4 applying, i.e. We haven't provided the addresses in the claim form. We were only notified of this change in position when we received Ms. Chung's skeleton argument, which was only served 1 working day before this hearing on Tuesday. So there are a number of problems that arise with this approach. And in my submission, that change of position is enough of a reason for the court to refuse to exercise its discretion, because the basis on which the application was made necessarily dictated the evidence that was filed by both of those claimants in response to it, and they have been prejudiced as a result of not being told the basis on which the application is pursued today. So the applications themselves were issued on the 15th of March 2023. I don't propose to turn them up, but the application notices are in section F at page 265. In support of the application, Ms. Taraskova filed 2 witness statements in identical terms. And Your Excellency, we've been through those, and I specifically took you through paragraph 11, which identified the relevant rules under which an order can be made, and we saw that only subsection 1 was highlighted. Now, we understood from that evidence that the jurisdictional threshold relied upon by the defendants was solely that the claimants were all resident outside of the UAE. And as I said at the start, Your Excellency is undoubtedly familiar with the way in which these applications usually come about, which is prior to the application being issued, the applicant will write to the set out the basis on which an application could be pursued, and will then make inquiries about the respondent's position. And part of the reason that's done is to avoid applicants jumping the gun and making unmeritorious applications that only seek to delay proceedings and incur unnecessary costs. And it's important to note here that no time prior to issuing the applications did the defendant's lawyers write to the claimant's lawyers to make inquiries about the residency status or about their addresses in the UAE or their asset position. None of that is done. So what we were faced with on the 15th of March is an application that was issued with no notice to the claimants, where the only basis on which the application is said to be pursued, or the only legitimate basis that could be inferred from the evidence, is it was being pursued on the basis all 3 were resident out of the jurisdiction. Now, that is very much a binary question. Are you resident in the jurisdiction or not? Whilst it can involve a degree of fact and consideration, in the case of Mr. Reuter and Mr. Pianise, it's a yes or no question, and they've provided evidence to show they've been there for over 15 years and they're permanently resident there. So both of them, Mr. Reuter and Mr. Pianise, provided the evidence necessary to show that they were permanent residents in the UAE, and that is not challenged by the defendants. So given there was no other basis on which the application was put, and it was a binary question, here is the evidence, we are residents, there was no need for them to provide any further evidence, including about their asset position, because they had a complete answer to what was a weak basis for making the application in the first place. Had the defendants written to the claimants and specifically asked, are you resident in the UAE, they would have had the answer, yes, here is the evidence, and it would have prevented the application being made in the way in which it was. And if I can take you to the respective statements of Mr. Reuter and Pianise, it's at section F, and this is particularly important to how the application is now put. The first one is document 4, page 274, and this is the statement of Mr. Reuter. Again, he makes an identical statement, more or less, for claims 108, but I'm only going to take Your Excellency to this one. I don't need to take you through all of the evidence, Your Excellency, which I'm sure you've read, but what I want to just draw your attention to is that right on the first line, he says, I, Alexander Reuter of Villa 20, and then he sets out his address in full there. And if we go to page 278, paragraphs 13, subsection 3, again, if we look 3 lines from the bottom, he confirms there, my current address as stated at the top of the witness statement is where I currently reside on lease. He provides evidence of that, and then he says I'm regularly paying bills at this address. If we look at Mr. Pianise's second witness statement, which is at page 305, again, I just want to highlight the 2 points. We can see at the top, he's provided his address in Dubai, and then if we go on to 13, subsection 3, which is at page 309, He also says, 4 lines from the bottom, my residential address is stated at the top of this witness statement is where I currently reside on lease, and I'm regularly paying the house utility bills issued in my name, and he provides evidence of that. So what is clear from this in my submission is that Mr. Reuter and Mr. Pianise, they are not seeking to conceal or otherwise evade providing their addresses. Indeed, they have voluntarily provided the addresses in their witness statements. So whilst their addresses is not stated in the claim form, they have openly and willingly provided their addresses in the witness statements. And they've done so at a time where the defendants did not tell them they were pursuing an application under 25-102 subsection 4 for failing to give an address in the claim form. That's basically an alternative weak plan B, where they failed in their original basis for making their application. Had they written to the claimants to say, what is your address? They would have been provided with them on the first time of asking, just as they were voluntarily provided in the witness statements. And had the defendants conducted themselves reasonably and proportionately and made those inquiries, all of this could have been avoided. So the defendant's conduct is significant in my submission, because it's not for the claimant to guess the basis on which the defendant pursues his application. It's for the defendant to specifically state the basis on which he pursues that, so that the claimant is aware of the arguments being made and they can respond with the appropriate evidence. Had we known it was going to be under subsection 4, we would have put in further evidence about the asset position and so forth. But they simply failed to do that. And the other point, Your Excellency, is they have had the witness statements of Mr. Reuter and Mr. Pianise since the end of March, so 2 months ago. They've had these statements for 2 months. They filed no evidence in reply, as they were entitled to under the provisions of the RDC, nor did they write to us prior to Ms. Chung's skeleton argument to say that they would be changing the basis of the application. So the conduct has completely prejudiced the claimants, because the evidence opposing the application was limited to the weak jurisdictional ground which they advanced in the first place. And because Mr. Reuter and Mr. Pianise had a complete answer to that, there was no need to provide further information about their address or their assets or anything. Had they told us at any point within the 2 months we're concerned about this, we would have provided the information. So, Your Excellency, even if you were to permit the defendants to change the basis on which they pursue the application late in the day and find that the jurisdictional gateway at 25-102 subsection 4 has been met, the question of discretion should be considered in relation to each threshold condition separately. And what the authorities suggest, Your Excellency, and I'll take you to it in a second, is that it's very rare for a court to make an order for security for costs simply because the address has not been provided in the claim form. And I rely on an English law authority called Berrewala and Woodstone Properties to make at this point. If I can ask Your Excellency to turn that up, it's at section H, document 2, page 586 is the start. I'm going to go to 591.
Okay.
And just for summary, Your Excellency, paragraphs 32 to 36 set out the basis on which the application was made, which is that there was a failure to provide an address on a claim form. In this particular case, it wasn't a failure to provide an entire address. It was only an apartment number. The rest of the address had been provided. But what is set out at paragraph 39, you can see what the judge is saying there. It is clear from the authorities and as a matter of principle that the question of discretion should be considered in relation to each threshold condition separately. That is the condition set out at 25.102. In stunt, Mr. Justice Warby set out the difficulties that had arisen or might arise in relation to the absence of the provision of an address for service. In stunt, for example, it had proved difficult to contact or serve the claimant. No such difficulties arose in this case. Nonetheless, he, being Mr. Justice Warby in the other case, concluded at 47, all this said, I do not believe that I would have granted an order for security as a matter of discretion on the basis of this rule. And then we look at paragraph 41 below. If I can just invite Your Excellency to read that paragraph to himself.
Okay.
So Your Excellency can see that in respect of that case, following what would be the normal route, a request had been made for the claimant's address and it had been provided at the first time of asking. That becomes important later on. And then going on to page 592 at paragraph 46, we can see the defendants did not raise their concern about the technical breach, that is the failure to provide the apartment number and the address for 9 months. And it presented no difficulties in the conduct of the claim and the counterclaim. 47, the judge refers to another case of Reuter and Reuter. Nicholas Strauss QC, sitting as a deputy judge, again on the facts of that case, did not exercise his discretion to grant security for cost based on the failure to provide the correct address. And then you can see she cites the ratio from that case. The requirement to state the claimant's address in the claim form is a requirement of the rules, not a mere practice direction. In any event, the claimant's request for Sohan's address was not put on the basis of the practice direction. Claimant's solicitor merely asked for his address, to which Sohan's solicitors replied the claimants already knew it. There is some material in the evidence that suggests this may have been so, and in any event, the address has now been given in Sohan's witness statement, backed up by supporting documentation. Your Excellency, the same's been done here. We've provided the addresses in the statements unprompted and given the leases to evidence it. So in these circumstances, even if I had taken a different view on the construction of the rules, I would not have exercised my discretion to order security on this ground. And the judge goes on to say, it would be rare for the court to make an order for security for costs against an individual based in England and Wales without more. For the court to make an order for security costs, it must be satisfied as just in all the circumstances, which is the exercise of a broad discretion. I have considered all the circumstances in relation to the breach of CPR 16. Whilst the omission of the apartment number in the claim form amounts to a technical breach of 16, it is a minor breach in this context. Even on the claim form, the entire address other than the apartment number was given. Full address was on the particulars of claim. It took 9 months for KDP to ask for the address. It did not preclude the defendants from fully participating in the proceedings or pursuing their defense. The defendant's evidence is not compelling. I simply do not accept that as against the defendants, there was any prejudice caused by the missing apartment number in this claim form. So in my submission, Your Excellency, the court should follow the English law approach, given the fact that RDC 25 is modelled on CPR 25 in virtually identical terms. And that English law approach is that the court should not make an order for security for costs against individuals based in the jurisdiction without more. The court should refuse to exercise its discretion in this case to make an order, particularly where the defendants did not notify the claimants of this alleged concern until 1 day before the hearing, therefore prejudicing our ability to put in evidence specifically responding to the point. The defendants made 0 attempts. There is not a single correspondence Ms. Chung can take you to that shows that the defendants made inquiries of Mr. Reuter and Mr. Pianese or their legal representatives to provide the address. The claim has been ongoing since December 2021, and it's taken 18 months for the defendants to raise an issue about the address. There is a vague reference to it in Ms. Turaskova's witness statement where she says we don't have the address, but she doesn't highlight that as being a particular concern. She doesn't highlight subsection 4 as being the jurisdictional gateway on which the application is pursued against this too. And the lack of address on the claim form, as with the Berawala case, has presented no difficulties to the defendants in participating in the proceedings or pursuing their defense. They've presented absolutely no evidence about how they have been prejudiced by not having Mr. Reuter or Mr. Pianice's address. And there has been no element of concealment by the claimants because, as I said, they voluntarily provided their address in their witness statements, provided documentary evidence supporting that's their address, and they provided that evidence without being asked to do so by the defendants and without knowing this would be the basis on which the application is pursued. So that shows there is no concern and the claimants are not seeking to take evasive action. So insofar as this is even an issue, Your Excellency, which is not, had they written to us and asked us, we could have provided the addresses, or the claim form could have been amended to just include the addresses in there. Those were the easy fixes. They faced no prejudice whatsoever. So we say the application should be dismissed on that basis. The final point I wish to make in respect of Mr. Reuter and Mr. Pianice is about the merits of the claim. Your Excellency, I won't repeat what I said in my submissions earlier, but it equally applies to these two. And my submissions are also set out in paragraphs 40 of my skeleton. The claimant's claims are almost certain, or there is a high probability that they will succeed, and the defendant's defense will fail. This is really a case that is ripe for immediate judgment, and my client's position on that is reserved. So for those reasons, I would invite the court to dismiss the application for security for costs against the claimants completely. Your Excellency, obviously, we're going to wait for your decision on the principle as to whether they're entitled to it. But I don't know whether you intend to give us that decision now or whether judgment is to be reserved. If judgment is to be reserved, then it may be appropriate for me to address you on quantum as well.
Judgment to be reserved.
Sorry, Your Excellency, I didn't quite hear
Judgment
that.
to be reserved in relation to the decision, yeah.
In which case, with Your Excellency's permission, I will make a few brief submissions on the quantum, because if the court is minded to make an order for security, which I say the court should not make because the discretion should be exercised in the claimant's favour, the quantum that's been provided is absolutely absurd. This is a simple debt claim, which, as I showed earlier, will turn almost entirely on two questions of law, which the defendants and Ms. Chung in her skeleton has identified at paragraph 7. That is the limited ambit of what this case is. And it actually all turns on English law, all of which favours the claimant. There are very limited facts in dispute. And Ms. Chung did her level best to try and say, oh, we're going to need a detailed examination as to attestation and whether a witness was there or not. First of all, it's going to become irrelevant because the deeds are still enforceable. The guarantees are still enforceable as a contract. But even if we're going to have a dispute on that fact, the reality is that's not a detailed explanation. That's a short statement of competing events as to whether someone was present in a room or whether they witnessed the signature or not. That's not a detailed factual dispute. But the fact that this dispute is actually very limited and will turn almost entirely on questions of law is reinforced in my submission by the fact that the claimants have confirmed they are likely to produce only a limited number of further documents to what they have already provided. And the defendants themselves in their case management information sheet say they will only produce between 50 to 100 documents. That's in the region of somewhere between 200 and 300 pages. Now, I'm intrigued as to what those documents exactly will be, but the fact that they're only saying at a minimum they're going to provide 50 additional documents and at a maximum 100 just shows there isn't much to this case by way of factual dispute. And just for Your Excellency's reference, the CMIS for the defendants is at section E 259. So in my submission, there's absolutely nothing complex about the issues in this claim. It's a simple debt alternative breach of contract claim with an alternative claim in restitution. And the principal value of both claims in round figures is $947,000. And notwithstanding this, the defendants estimate that their costs of defending the claim to trial will be approximately $1.15 million. So they say their costs are going to exceed the principal value of what is a very simple debt contractual claim. And in my submission, that's absolutely absurd. And there is no circumstance in which those estimated costs can be genuine. I've set out at paragraphs 48 of my skeleton that the defendants have actually failed to comply with Rule 25.99 of the RDC, in that they have failed to provide a statement of cost of the sums that have already been incurred, which they must be aware of. And they've also failed to provide the required detail to support such statements of costs for estimated fees going forward. And that's normally set out in 38.34, and it the hourly rates, the estimated time that's going to be spent, the seniority of the fee earners that are going to be working on the case, and so forth. So it's clear that certain costs would have already been incurred by the time the application was made on the 15th of March. And the defendants have provided no evidence of those, as is required by Rule 25.99 subsection 3. Had they provided that, it would have allowed the court to actually conduct an assessment and form a view as to what was reasonable and proportionate, and whether the estimated costs in Ms. Turaskova's witness statement was inflated, which they clearly in my submission are. Now, of course, the party can sign a witness statement estimating what those costs would be. Normally with these applications, Your Excellency will know, you will get a statement from the solicitor that provides a full breakdown of what the costs are in the form of a statement of costs. And the rules say they should mirror form P38-01 as closely as possible. And that definitely has not happened here. We have a table included in the third defendant's witness statement that gives no information at all about how they say the costs are going to be incurred. But by also failing to provide the underlying information about estimated hours, hourly rates, lawyers of which seniority are going to be working on it, the court is further constrained in being able to form a view as to what is reasonable and proportionate. So the reality is the court doesn't have the evidence or the underlying information it needs to actually form a view as to what the defendant's costs are going to be. It's absolutely absurd to suggest it's going to be anywhere near 1.1 million, which exceeds the value of the principal claim on what is a very straightforward, simple claim. So in my submission, I would be very surprised if on a claim like this one, if the costs were to exceed a range of $75,000 to $100,000, given the limited issues in dispute. I'd be incredibly surprised if it gets to that top figure. But the problem is there's simply no legitimate and reliable evidence and information on which the court can form an assessment of quantum. So unfortunately, if the court is minded to actually make an order for security, it's going to have real difficulties trying to figure out what the legitimate estimated costs are, what the incurred costs are, which they were obliged to provide evidence of, and therefore what's the appropriate level of security to order. So, Your Excellency, those conclude my submissions on the defendant's applications.
Thank you. Ms. Chung, anything from your side?
Yes, Your Excellency. I have 3 points, and I will also be addressing the additional point on fourth point on quantum. But the 3 points that I propose to deal with first are responsive to Mr. Biru's submissions. And the first point is going to be about the evidential burden. The second is the law on passante and whether or not it applies to a claimant that is resident out of the UAE, which we say it does. And lastly, dealing with the merits of the claim, which we say simply shouldn't be a factor to be taken into account in your exercise of discretion. But firstly, dealing with the evidential burden in this claim. And the claimants have perhaps spent quite an amount of time saying that there's simply no evidence as to the practical difficulties that the defendants are going to encounter. Well, that's actually no answer at all to the oral submissions that have already been advanced in relation to Mr. Bledjian, because it is simply evident, we say, from his witness statement that selling a property within 14 days and having the cash to pay up on a cost order is going to be nearly impossible. The claimants have suggested that we should be following the approach in Al-Kharafi, but as Mr. Biru has correctly pointed out, that is a case about whether it would be practically problematic to enforce in Kuwait. And that's why an expert legal opinion from Kuwait was required. Well, that's simply not the case that we're advancing here. The case it is about whether or not one can sell a property within 14 days and have the cash in the bank account to pay out. Well, that's simply, we say that's simply what the claimants say are simply relying on a technical and unattractive attractive argument to say that there hasn't been evidence adduced. But because when we look at Mr. Bledjian's witness statement, common sense can tell you that that's just practically impossible. And we do say that the court shouldn't be relying on such a technical answer and instead exercise its discretion in favor of the defendants. There is also, in relation to this evidential point that's been heavily relied upon by the claimants, that there is criticism that we should have put in evidence for the valuation of Mr. Bledjian's property. But of course, Your Excellency will know that there is no way for really a third party to value a property in the UAE. We can't instruct a third party valuer for a property where we don't have legal interest in and we don't have the claimant's consent. So that simply falls away, we say. Having summarily dealt with the evidential point, I do propose now to deal with the law on passante, because it is extremely relevant as to, we say, the fact that the mere existence of a property alone is not enough to overcome the hurdle that there is a real risk in enforcement when a party is not resident in the UAE, as is the case with Mr. Bledjian. If I can just take you to tab I.
Yeah.
And that's page 693. That's the second tab. Sorry, section I. So again, we're back at, sorry, Your Excellency, have you got the page in front of you?
693, yeah?
693. If I can
Okay.
just ask you to pause there, because we're back at logothetis and passante. Now, the claimants have made quite a large, have spent quite a large amount of time also saying that this isn't actually applicable to Mr. Bledjian, that this case is only about the the dicta in here is really only about the impecuniosity of a claimant company, and that there's even been a suggestion that I have somehow misled the court. I'm not going to ask you to turn in the bundle to paragraph 15 of my skeleton, but what I propose instead is simply for myself to read out paragraph 15 of my skeleton, which says, while the dicta in Holyoke dealt with the position of an impecunious company, it was applied in relation to passante, nevertheless, to assess the position of a claimant who was non-resident in the relevant state. So that, I think, deals summarily with the argument about that should there be any confusion by the court at all. But in fact, let's look at passante a bit more closely. If we can just go to page 692 at paragraph 47, this tells you exactly where the dicta I have cited in my skeleton comes from and the context in which it's being used. The judge simply starts, I now consider the assets on whose presence in a convention state the claimants rely. So that simply is the exact position in which we find ourselves, or Mr. Bledjian find himself in. And then he deals with the real estate in Greece. So turning back to page 693, and we look at paragraph 51. And I simply don't see how we can say that this isn't about a claimant who is not resident in the UAE. It says, in these circumstances, there must be real doubt about whether, and if so, in what timescale, the House could in reality be the subject of an enforcement action. Certainly, this dicta applies very readily to the current case today. And then it says, in Holyoke and Candy, Justice Nugie said, in the context of a Condition C case, so that's quite clear. The judges apply. So Condition C, as Mr. Biru has already taken you, is about the impecuniosity of a claimant company. So he's using the dicta in an impecuniosity company case and applying it to a non-residency case. Why? Because the dicta simply applies. It is also logical in a non-residency case.
That's not correct. I'm sorry to interrupt. That's incredibly incorrect. You have to be precise. It's about a claimant company. It's not about non-residents. He's dealing with non-resident claimant companies. There's a difference between that, which is subsection 2, and subsection 1, which applies to individuals. My submissions were not about this is the same for individuals. This judgment, Passante, is about a claimant company. It's being brought under subsection C, not subsection A. It is misleading to say it applies to individuals. And that's what paragraph 47 is. It's talking about presence of assets in respect of claimant, the claimants being companies, not an individual.
Okay, well, regardless, it's quite, I'm not going to deal with that because I think perhaps the interruption was slightly uncalled for. But in any event, we do say that paragraph 51 quite fairly deals with whether or not that there must be real doubt as to whether and in what timescale the house could in reality be the subject of an enforcement action. And certainly in paragraph 52, we then go on such considerations, in my view, apply a fortiori in a case such as the present one, considering a residence. So regardless of whether the first, even if we take Mr. Biru's submission on its at its highest, we say that this dicta simply also applies in relation to into a non-residency case. And certainly, if we look at the DIFC rules at 25.102 and the purpose of a security for costs, well, we've already taken you, Your Excellency, that the overall purpose of a security for costs application is so that a defendant can enforce a cost order if the court makes an order to do so. And that's really the point that's being dealt with today, which is that the defendant should be entitled to security if there's reason to believe that in the event of his succeeding and being awarded the cost of the action, he will have real difficulty in enforcing that order. And it is usual that in an order, the costs are ordered to be paid within 14 days. And we say that the dicta in Passante clearly is also applicable here. So having dealt with Mr. Biru's case, even at its highest, we say that that dicta still falls to be considered and to be taken into account in the discretion by the courts. But then the last point we deal with is the merits of the case. And Mr. Biru and I are happily agreed, again, that the general rule is that you shouldn't be taking into account the merits of a case at all, unless the claimants are almost certain to succeed. It has been suggested that there are no complicated issues of fact, there are no complicated issues of law. If I can just take you very quickly to section C, tab 2, and page 152.
Okay.
I'm afraid my bundle's being quite slow, but what you should see there is that simply there has been no witness attestation at all. The deed hasn't been attested to by a witness. And that's the case with also Mr. Reuter and Mr. Blesian. Well, even in the case of where the first primary argument of the UAE penal code has fallen away, the claimants still have to get over the hurdle, which is that under English law, at section 1, subparagraph 3 of the Law of Property Miscellaneous Provisions Act 1987, which is set out in the defence, the instrument is valid. An instrument is only validly executed as a deed by an individual if and only if it is signed by him in the presence of a witness who attests the signature. Now, Mr. Biru has taken you to signature living, and I am going to take you to the same case now. If I can just take you to section H, tab 2.
I think we'll leave this one to the courts later on to decide whether it's a deed or whether it's a contractual obligation. I need an explanation on why should I grant security of cost, which you already gave me which you gave me reasons, and the defendant and the claimant as well provided his reasons. I don't want to jump into the merits of the case. It's basically a case, it's basically an application for security of cost. So at this stage, I will not be deciding whether it's a deed or whether the deed then, if it wasn't a deed, it's a contract. This is not, it's not my purpose here. My purpose is whether should I grant security of cost or not.
Thank you, Your Excellency.
And this is it.
For that. Thank you, Your Excellency, for that clarification. Well, then, the only reason why I'm going into the merits is because the claimants have relied on it in argument. But I completely take, and I think we are aligned on that the merits shouldn't be considered in this security for cost application at all. Definitely. So that certainly ends, the 3 responsive points to Mr. Biru. So I'm going to quickly deal with quantum on and with no disrespect meant to the court at all. This proceeds, of course, on the assumption that security is granted. Now, Mr. Biru has made quite a few submissions about the appropriate quantum in the case. Certainly, the defendants have, as a standard, tried genuinely to provide a detailed breakdown of costs, which is divided along each stage of proceedings. There has been an element of estimation, given that the defendants are looking ahead at the future and anticipating worst case scenarios, factoring that into the calculation. For example, it has now been suggested in this CMC that in the later CMC, that there is going to be a need for an amended reply. There has also been quite a huge reliance on the idea that this is a straightforward and simple claim. But certainly if we go to the claimant's case management information, Your Excellency, I don't propose that you jump to it, but so you have the reference, it's at page 257 at the very top. And apparently this really straightforward and simple claim is going to take 3 to 5 days, which goes to highlight that this simply isn't a case that's ripe for immediate judgment or anything, because even on the claimant's own estimation, they think it's going to take 3 to 5 days to get through. And certainly we say that the court will no doubt have in its vast amount of experience an idea of what the appropriate figures and the amount of security is going to be, which of course the defendants would be happy to accept. So having dealt with the quantum point, those are my submissions. Thank you, Your Excellency.
Thank you. I think I heard enough to decide on whether to grant or not the security of costs. So the remaining is the case management conference, the CMC. So before we jump into the CMC, we'll take a break. Yeah?
Yes.
Yes.
I think 20 minutes break. Yeah? So
yes.
we'll resume. Yeah?
Sorry, actually, I was going to ask, is that 2025 past?
Yeah. Okay. Then we'll resume on the CMC. Yeah.
Thank you.
Thank you.
Thank you.
I think we're all here, Your Excellency.
Yeah. So we may start now on the CMC.
Yes. Your Excellency, there are 3 remaining matters that require the court's attention today. I think happily a lot of the issues the parties have been able to discuss and agree. The 3 matters go to, 1, the question of whether there's a need for expert evidence on UAE law. The second, deals with the point about whether there's a requirement for the reply to be amended. And the third goes to the timeline of some of the steps set out in the case management order. So if I may just go through each of those and set out what our position is. So, as I say, the first matter goes to the question of whether there should be expert evidence on UAE law. Ms. Chung, in her skeleton argument at 31B, says that the parties have agreed that expert evidence on UAE law should be adduced. That's not quite my understanding, which is that the parties had agreed to adopt a neutral position and ultimately leave it up to the court. However, insofar as the court directs that there should be expert evidence, the parties have been able to agree the 4 issues that should be covered. Your Excellency, should you want to look at that, that's set out in the draft case management order at section E, document 5, page 245.
Mm-hmm.
I don't propose to turn it up, but that's the reference. It's also at 22 of my skeleton arguments. Now, the expert evidence ultimately goes to the question of whether Articles 458 and 459 of the 2021 UAE Penal Code apply to the transaction in this case, and if so, whether that renders the loan agreements invalid and unenforceable as a matter of English law, i.e. if it's contrary also to the head of policy under English law. So the question on UAE law ultimately turns on a construction, largely, of Articles 458 and 459, and legal submissions. Now, I've set out at paragraph 22 of my skeleton argument the relevant guidance set by the Court of Appeal in the case of Fidel and Felicia and Faraz. And if I can just ask you to look at that, Your Excellency, it's in my skeleton argument, paragraph 22, which is section H, document 1.
Okay.
And it starts at page 429. I think this will be easier than taking you to the authority itself. What the Court of Appeal said, and what I've set out at paragraph 73 there, is that there is now in the DIFC a presumptive rule that the court should adopt what is known as the international approach, which is accepting submissions on non-DIFC law as part of legal submissions made by counsel, and that's normally what is done in international arbitration. Your Excellency is undoubtedly familiar with these approaches. However, what paragraph 73 says is this presumptive rule is now just the starting point, and the trial judge always has a discretion to proceed in a manner which he considers most beneficial for his education, particularly in a system of law with which he is not confidentially familiar. Now, Your Excellency will know the DIFC court has on many occasions interpreted and applied UAE law without reference to expert evidence, not least because we have experienced and highly qualified judges such as yourself who do so. So the key question is likely to be who is going to be the trial judge and how familiar are they likely to be with UAE law. For example, if Your Excellency was to be the trial judge, then in my submission there would be no need for UAE law. And there'd be no need for expert evidence on UAE law because Your Excellency is obviously familiar with it, and the parties could make their submissions both on the construction of Articles 458 and 459 as well as to the applicability. So my clients take a neutral position on whether there should be expert evidence or not, and we remain entirely in the court's hands. We're very content to advance our case on the basis of legal submissions without reference to expert evidence, but equally, if the court determines that that would be beneficial for the education of the trial judge, then we're content for expert evidence to be adduced dealing with the 4 issues that have been agreed by the parties. So that's my position on the first matter. Would it make sense for me to address you on the other 2 matters before you hear from Ms. Chung, or would you like to deal with it on an issue-by-issue basis?
Yes, please.
So the second matter, which requires the court's attention, is whether there is a need for an amended reply to be filed that formally records our position in respect of a new defence that's advanced by the second and third defendants. Now, Your Excellency, we dealt with this briefly during the security for cost application, but if I may just take you through the history of this amendment. Her Excellency Justice Maher al-Mahiri on the 24th of March granted the claimants permission to amend their particulars of claim to introduce a restitution claim in the alternative, as well as to make some corrections. And she issued her order, which included a consequential directions for there to be an amended defence. There was no direction by Her Excellency for an amended reply to be filed and served. Now, that order, insofar as Your Excellency wants to look at it, is at Section B, Document 8, tab 112. I don't propose to turn it up, but that's what it says. The substantive amendments in the re-amended particulars of claim, Your Excellency may well have seen, deal specifically with the claim in restitution. So if I can ask you to just bring up one, it's Section A, Document 3, and it starts at page 24.
So there was an amendment to the particulars of claim?
Yes.
And then an amendment to the defense?
Correct, but I just want to take the court through the amendments to bring to the court's attention why I'm now having to bring this up as a potential need to make an amended reply.
Okay.
So page 24, this is the substantive amendment that Her Excellency Justice Maher al-Mahiri granted us permission to amend. So you can see the section starts V subparagraph 8, claims in unjustment enrichment. So that was the extent of the substantive amendments. And then at document 4, you'll see the amended defense. And if you go down to page 88.
Okay.
So when the amended defense was served, for which they had permission to serve, you can see the second part of the highlighted text, claim in unjust enrichment. That's the actual amended defense and response to the amended particulars. But what you see further up is the deed is enforceable. That is an entirely new defense that should have been advanced when they filed the original defense, but wasn't. Instead, what the defendants did is they introduced this new defense and this amendment without notifying the claimants and without actually seeking permission from the court to do so. Now, the defendants may well argue, well, we could have put it in any event or whatever it may be. But the fact is that's what they've put into the new defense. And because they introduced this by way of an amendment and there was no provision for an amended reply, the claimants haven't been able to formally respond to this in a pleading. Now, our position is as set out in paragraphs 12 and paragraphs 20 of my skeleton argument, and that's in response to claim 107 and 108, which are virtually identical. And I've also set some of those out in my submissions today. But in summary, Your Excellency, what I want to do is make it abundantly clear to the defendants, and I want it on the record, that the claimants in each claim deny that the guarantee is invalid and unenforceable as a deed. However, as you heard in my submissions earlier, I also want to make it clear and place it on the record that even if both guarantees are invalid as deeds, they are still enforceable as contracts as a matter of English law. And the defendants are stopped from claiming that the terms are unenforceable as against them. So that's what our response and our position is. But because Her Excellency's order didn't make provision for an amended reply, likely because no one anticipated they would put in a new defense, I simply wanted to raise this issue now to see whether to get some direction from the court. I'm perfectly content to amend the reply to reflect exactly what's in my skeleton argument and file that by the end of this week on Friday, if Your Excellency thinks that's necessary. Alternatively, if Your Excellency takes the view that I've made that position clear and therefore the defendants should proceed on the basis that those are the arguments we make, then there doesn't need to be an amended pleading. Now, I should also point out, because Ms. Chung raised it during her oral submissions, insofar as Your Excellency says this should be memorialized in the amended reply and gives us permission to file that by the end of this week, there would be no consequential responses by the defendants. They don't have to respond to it. That would basically be an amendment to the last pleading in the case. So there's not going to be any additional real cost to them beyond reviewing what I say in that pleadings. But what we actually say what I would say in the pleadings is reflected in the skeleton argument. So they know what our position is on that. So Your Excellency, I'm really in the court's hands as to whether you form the view that I should memorialize this in the reply, or whether by stating it as I have done on the record and made it clear to the defendants what our case is, whether that's enough. The third matter that requires the court's attention today is the timing of certain procedural milestones in the draft case management order. And if I can ask Your Excellency to bring that up, it's at section E, document 5, page 243. So, Your Excellency, this is an order that we've submitted for your consideration and approval. It was agreed at the time it was filed, and the parties had agreed to all of the timelines set out, which you can see at paragraph 3, for example, meant that standard production of documents would happen by mid-July. Yesterday, lunchtime, the defendants sought to resolve from these agreed dates, and they're seeking to push back some of the dates for compliance by approximately 7 to 8 weeks. And I understand that they're now looking to push standard production back to the 7th of September, push witness statements back to the 31st of October, and insofar as Your Excellency forms a view that there should be expert evidence, push that back to the 30th of September. Now, we don't agree, or we did not agree to those dates being pushed back, Your Excellency, and I'll come on to the reasons why. But the reasons the defendants now seek to push back some of these dates by up to 2 months in some instances is because they say the person with conduct of the case is going to be on holiday for most of the summer. They're going to be traveling and they don't have Wi-Fi. Your Excellency will be familiar that the court rarely accepts that as a legitimate reason to push back dates that had been agreed. There is an impetus to get this case concluded as quickly as possible. It's been ongoing for 18 months. And as of now, in that 18 months, we're only at the CMC stage. So Your Excellency will understand my client's frustration, which is they've provided all of this money that's been accepted as being received by the defendants, and they haven't got it back since 2019 when it was due. So they've been out of pocket for 4 years. They're obviously keen to get this resolved as soon as possible. Instead, they've been faced with constant applications and delay tactics and things like that. So I don't accept a summer holiday as a legitimate reason to push back the dates that have been agreed, but I make 3 points in respect of that. The first is the dates in the case management order were actually agreed by the parties' legal representatives over a week ago. So it's inconceivable in my submission that the lawyers for the defendants were unaware of their own holiday commitments prior to confirming their agreement to the dates provided for in this case management order. The second point is they say their estimated costs are going to be $1.1 million. I find it hard to believe in those circumstances there's only one person who's capable of working on this case. So they should be able to accommodate whatever procedural deadlines Your Excellency sets. And the third point is the claimant rarely accepts, or the court, sorry, rarely accepts vacation plans as a reason to delay procedural milestones. It's down to the lawyers to arrange their schedules to meet the deadlines imposed by the court. And as I say, in this particular one, this had already been agreed by the parties. They are sensible dates that were agreed by the parties that means this can be dealt with efficiently but comprehensively. And the court has already taken account of the dates that the parties had agreed to and had provided dates for a trial starting the week commencing the 25th of September and provided a date for a PTR, I think, at the end of August. So insofar as Your Excellency was to acquiesce to the request of the defendants and move back the dates, it would have the consequence of also losing the trial date in September. And we don't know when we could then get a new date, which would have to be fixed, but it certainly wouldn't be until the end of the year or possibly going into next year. And then we may well get excuses about Christmas holidays at that point. So the dates that had been originally agreed by the parties should be maintained in my submission. And there's no reason to push them back just because of people's summer vacation plans. That both firms are more than capable of finding additional resources to help get through these processes. So those are the 3 outstanding matters as far as I'm aware, Your Excellency, and my submissions on them.
Okay, in relation to document 5 of section E,
Yes.
The document before me does not contain any dates of trial. It's highlighted
Yes.
in yellow.
Yes, Your Excellency. What we did is we had to get the dates from the registry, but that could only be done once the parties had agreed the earliest date for trial. So the parties were in correspondence with the registry, and I'm sure I can find the email or the registry can provide it. But the registry did confirm to us, to the parties by email, that there was 4 dates available for the trial. That was the 25th, 27th, 28th, and 29th of September. I'm not sure if that's actually been fixed, but that's what the registry proposed, and I think they were waiting for confirmation from the parties. And I believe the date for the PTR was the 31st of August.
In any ways, the court will not delay this matter further. So the court are keen to resolve this matter as soon as possible, given that the parties agree on the available timetable. But to delay the matter for summer vacation is not an option, especially that this case have been going on from 18 months.
Yep.
And we also in the court do have those KPIs to resolve matters in a timely manner rather than delaying for reasons that cannot hold in court. Yeah. And in relation to the claimant request to reply, to amend the reply to defense, reply is granted. Amendment to the reply is granted, but it will be as a response to the defense only. Nothing more added. If something more is added to the amended reply, then the court will not consider the document. Yeah.
Yes, thank you, Your Excellency.
In relation to the first point, Ms. Chung, you can respond.
Your Excellency, sorry, you said the first and second point, but I think I am neutral on the point with as regards the expert report. Certainly, I clarify what's been said in the skeleton. That was it could have been better said, but essentially my position is similar to Mr. Biru's. It's the same as Mr. Biru's, and certainly the same. The defendants are also neutral in the reply. However, I think the submissions that I was hoping to make, Your Excellency, was in relation to the dates, because it's been said by Mr. Biru that they were agreed, and that is true to an extent, that they were agreed, but it was discovered by accidental oversight. So what happened was that the case management information sheet that the defendant filled in had the dates that the defendant was proposing. Unfortunately, because of this oversight, the case management order that wasn't included in the case management order, and that didn't come across to the claimants as a result. And so unfortunately, and this is entirely the defendant's and the fault of the defendants by accident, this case management order was put in with the dates that were suggested by the claimants. And that's certainly something which the defendant offers apologies for in this to both the claimant and the court. But the reason why it's not just summer vacation plans, but also that because the defendants it's not just the lawyers, the persons with conduct of the case, which will be traveling and on annual leave, but also the defendants themselves. What the defendants are trying to avoid is a situation where, because everybody is going to be in several different countries and there's emails flying about, what we don't want to have a situation is that there is a deadline in the court order, and then the defendants must seek an extension and further delay. And as a result, there might be another application to the court asking for leniency because of an extension that's being asked. It seems perhaps more efficient, when you take into account that the possibility of things going wrong as a result of what we know is going to happen, to just push it back for the things to be dealt with from September onwards, and presumably to be dealt with within that quarter. Mr. Biru has said that, as I understand from what Mr. Biru was saying, the trial dates haven't been fixed yet. It's been proposed by the listings office. So to that extent, we're sort of operating in a vacuum of knowledge as to when the trial date can be. But certainly, given the efficiency of the courts, we would certainly hope that it would be heard within the quarter of the final quarter of 2023. And we haven't got evidence to say that, that's not going to happen. We are asking only for a 7-week delay in light of the fact that not just the lawyers, but also the defendants are all going to be in different countries, different time zones, and we are aware of the practical difficulties as a result. And we don't want further delay in this claim. We want to make sure that at the end of the day, everyone's going to be efficient. No one needs to seek an extension of time. So perhaps when you take a step back and look at that context, perhaps it'll be more efficient just to put it back just by 7 weeks along the dates that the defendants have proposed.
Your Excellency, may I just respond to some
Yes.
of those points that were made? The first point is that I accept Miss Chung's explanation for where the inadvertence comes, but it doesn't quite add up, because the draft case management order was sent to them about 2 weeks ago, and on the 26th of May is when they came back and confirmed both their agreement to the case management order as well as to the bundle index, which is what the parties were discussing. The issue with the CMIS only came up, as I understand it, a day or two ago, when it was filed later, i.e. after the dates had been agreed, and then they sought to change the dates on the CMO. So even if an inadvertence or not in discovering holiday plans, what I understand to be the main point of issue is that people are going to be away on holiday, defendants and all that. Yeah, quite frankly, it's for them to arrange themselves to comply with the court's deadlines. It's not for the court to accommodate their long vacations. And I think today demonstrates just how easy it is to do that, because I'm sat here in London, Your Excellency, and I think Ms. Chung is sat in Dubai. Yeah, with the use of technology, anything's possible. So if they want to go on holiday, it's for them to arrange to make sure that they nonetheless can provide the instructions and the information needed by the lawyers to comply with the court's timetable. And as the court says, the impetus is to get these things resolved as efficiently and swiftly as possible. And the timetable that's set out in the order that's currently before the court is one that achieves that and is efficient. And the court, I'm not sure what the current status is as to the trial dates. What the registry had done was ask the parties to confirm their availability by the 29th of May. Now, we did. I'm not sure if the defendants did, but it may well be that a trial has been fixed. That's something that the registry can confirm. But I just wanted to bring up those 2 points, noting already that Your Excellency has given an indication of the dates were to be maintained.
I was given the dates, but we did not. The courts did not yet list the hearing for September.
Yes, I believe that's correct, Your Excellency. And sorry, I just need to correct what I've said. My solicitor confirms that we haven't yet confirmed our availability, but the courts did confirm that those dates were
available on those dates. We're waiting for the parties' confirmation.
Yes, but what the claimants had done, and I apologize, this is the way they did it, Your Excellency, is in the case management information sheet, they had confirmed those were the trial dates, but they need to confirm with the registry the availability, which we are available to meet that September date.
In anyways, I still don't see a reason for a delay. And if any of the parties wants to file an application later on to extend the date, it must be accompanied by a sufficient reason, for it to be granted. So I'll accept the agreed dates. And in relation to the expert report, yes, I believe it requires an expert, because we have different judges. Some are locals and some are international judges who are not familiar with UAE law. So it's better to provide an expert on UAE law. So if it was a foreign judge, he can be able to understand from an expert on the law. Yeah.
Yes.
The interpretation of the law and what the law requires. So yes, we'll keep the expert report.
Thank you.
And the date shall remain the same. I think I don't see that the case requires lots of time. Yeah.
Yes. Your Excellency, that leaves the additional point, which I think you already addressed earlier, but the permission for the amended reply. Would 4 p.m. on Friday be
Friday is tomorrow,
sufficient? Yeah? Friday is tomorrow, or we should be able to achieve that. If it may make it more comfortable if it's 4 p.m. on Monday, Your Excellency, but I did say Friday, so I'm content to be held to that date.
Friday then.
Yes, thank you.
Anything else from the parties?
No, thank you, Your Excellency.
No, that's it. Thank you.
Thank you both.